Most men approach divorce the way they'd approach a fight. Emotional, reactive, immediate. They confront their spouse, make demands, threaten, move out, drain the joint account. And in doing so, they hand their spouse every tactical advantage the law allows. Here's what you need to understand. Divorce is not a place for vindication. It's not where you prove you were right. It's not where you get justice. It's not where you make her pay. The courtroom doesn't care who started the fight. The judge doesn't care who was the better spouse, and here's something most men don't realize until they're sitting in that courtroom. The judge does not want to hear about every fight you had. Judges handle 30, 40, sometimes 50 cases a day. They have 15 minutes for your hearing. If you walk in there trying to litigate 5 years of marital grievances, you're going to get a frustrated judge. And a frustrated judge is a dangerous judge, because when they're annoyed, they make faster decisions, and faster decisions in family court rarely favor the person who's being difficult. Section 401 of 750 ILCS 5 makes this explicit. The sole ground for divorce in Illinois is irreconcilable differences. No fault, no blame. The marriage failed. That's the only fact the court needs. Now let me give you the uncomfortable truth. The system is stacked against you as a father, not because the law is written that way. Illinois actually has decent statutory protections for fathers, compared to many other states. But bias exists in practice. Judges are human. They carry assumptions. And in family court, the default assumption is often that young children belong with their mother. You can fight that assumption. Section 602.7 lists 15 factors for determining custody, and none of them say default to the mother. But you're starting from a defensive position. Your job is to document so thoroughly, present so calmly, and comply so precisely with Illinois law that the judge has no choice but to award you the parenting time you deserve. You don't overcome bias with anger. You overcome bias with evidence. Here's the harder truth. Divorce is a no-win situation. You will lose money. You will lose time with your children, as you will lose the life you built. And the only question is how much you lose. Your job is to remain logical, know as much as you can, and get out with minimum financial and emotional damage. That's not cynicism. That's strategy. Because if you turn this into a revenge mission, if you make it about punishment, you will lose more. Your attorney will bill more hours. Your spouse will fight harder. The judge will grow impatient, and your children will suffer the fallout. React strategically, not emotionally. That's the difference between men who rebuild their lives after divorce and men who spend years trapped in litigation, broke, angry, and still fighting battles that don't matter. Let me be direct. Your anger is going to cost you money. Maybe your spouse cheated. Maybe she lied. Maybe she's planning to take the kids. You have every right to be angry, but anger is not a legal strategy. Anger makes you reactive. It makes you send the text message at 2 a.m. that her attorney will print out and show the judge. Anger is the tax you pay for losing control. And in divorce, control is everything. Here's the mindset shift. This is not a contest you can win. This is damage control. You're trying to protect your assets, secure your parenting time, and get out with your financial future intact. Think of it like a controlled retreat. You take what you can carry. You leave what you can't. Scorched earth costs you everything. Your first task is to gather information. Because once you file, everything changes. Bank accounts get frozen. Access gets restricted. Cooperation ends. Right now you have access. Use it. You need 6 documents. First, 3 years of tax returns. Illinois courts use this to calculate child support and maintenance. Second, 6 months of bank statements for all accounts. If your spouse drains the joint account the day after you file, you need a baseline. Third, retirement account statements. These are marital property and will be divided. Fourth, property deeds and mortgage statements. The house is often the largest marital asset. Fifth, vehicle titles and loan statements. Sixth, a list of all marital debts. Illinois divides debts the same way it divides assets. Why does this matter? Because knowledge is control. Right now you're operating on assumptions, but assumptions are dangerous in divorce. Documentation gives you certainty, and certainty gives you negotiating power. Once you have the financial picture, you face 4 decisions that cannot be reversed. Decision 1, do you file first or do you wait? There's no legal advantage to filing first in Illinois, but if your spouse is volatile, hiding assets, or threatening to take the kids, you file first. If your spouse is cooperative, you wait. Filing first is about timing. Decision 2, where do you file? Venue matters. Different counties have different procedures. Some require mandatory mediation. Some have judges with reputations for being father-friendly or mother-friendly. Research the local rules. Decision 3, what do you request in the petition? You don't get what you don't ask for. If you don't request joint custody, the default may be sole custody to your spouse. Use the statutory language from Section 602.7. Your opening position sets the range. If you ask for 50-50 custody, you might settle at 60-40. If you ask for every other weekend, that's probably what you'll get. Start high. Negotiate down. Decision 4. Do you need temporary orders? Temporary orders govern what happens while the divorce is pending. But understand this, whatever the temporary orders say often becomes the permanent order. Temporary orders are not temporary. They're predictive. Now the mistakes. Mistake 1. Moving out of the house. If you move out before a temporary order is in place, you create a presumption. Illinois courts look at status quo. If the children have been living primarily with your spouse for 6 months, the court is likely to continue that arrangement. Don't move out unless you have a temporary order specifying your parenting time. Mistake 2. Confrontation and escalation. Do not send angry texts or emails. Every communication is discoverable evidence. The judge does not want to hear about your marital drama. And if you walk into court with a list of every time she disrespected you, the judge is going to see you as the problem. Stay calm. Stay factual. This is discipline, not weakness. Mistake 3. Draining bank accounts or hiding assets. Section 503 allows the court to award a disproportionate share of assets to the party who did not dissipate marital property. Don't move money. Don't sell assets. Mistake 4. Using your children as leverage. Do not badmouth your spouse in front of the kids. Section 602.7 considers the willingness and ability of each parent to facilitate a relationship between the other parent and the child. This is where men lose custody cases. Yes, there is bias, but Illinois law gives you the tools to overcome that bias if you don't hand the judge a reason to rule against you. Mistake 5. Posting on social media. Your spouse's attorney will subpoena your accounts. Every post, every photo can be used as evidence. Set all accounts to private. Better yet, stop posting entirely until the divorce is final. Here's your 7-day action plan. Day 1. Secure the 6 documents. Make physical copies. Make digital copies. Store them in 3 places. Day 2. Open a personal bank account in your name only at a different bank. Update your direct deposit with your employer. Day 3. Consult an attorney even if you're representing yourself. Many attorneys offer free consultations. Day 4. Start documenting every interaction with your children. Keep a calendar. Day 5. Change all your passwords. Day 6. Photograph and inventory all marital assets. Walk through your house with your phone. Day 7. Draft your plan. Write out what you want. Custody arrangement, parenting schedule, assets, maintenance terms. Let me bring this back to where we started. Divorce is not a place for vindication. It's a no-win situation. The only question is how much you lose, and the answer depends on whether you can control your emotions long enough to think strategically. The men who suffer the most are the men who turn divorce into a revenge mission. The judge doesn't care. All you'll do is annoy them. The men who do well are the men who understand the reality of the system. Yes, there is bias, but Illinois law is better than most states. Section 602.7 gives you statutory tools. Joint custody is common. 50-50 parenting time is achievable, but you have to use those tools correctly. You have to present your case in a way that makes it easy for the judge to rule in your favor. Well, that means documentation. That means compliance. That means staying calm when your spouse's attorney is trying to provoke you. You don't overcome bias with anger. You overcome bias with evidence. Illinois law is neutral. The statute doesn't care if you're a man or a woman. It cares about evidence, procedure, and compliance. This is not about justice. It's about survival. The first steps matter. Take them carefully. Stay logical. Stay informed. Get out with minimum financial and emotional damage. That's the job. Check the description for free Illinois divorce resources, court forms, and statutory references. Subscribe for weekly breakdowns of 750 ILCS 5. This is not legal advice. I'm not an attorney, but I am a resource. Stay principled.